All right. Hello, everyone. And today we are going to be discussing the topic of what injuries qualify under New York law for pain and suffering. Welcome to another informative segment of Live with Mitch from the law firm of Proner and Proner. I'm your host, Mel McCoyup. And we sit down with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or anything interesting topics that you might find useful in your personal injury world. And just remember, folks, if you need to contact us, all consultations are free and confidential. Call us at any time at 1-800-321-1234. How you doing, Mitch?
Pretty good, pretty good. It's funny you mentioned I have over 30 years experience. I remember when I was a young lawyer, one time I was sitting in court and there were these two old lawyers in front of me, and they were old guys. And one of the lawyers was saying to the other one, I used to brag to my clients how long I've been practicing law. He says, now I don't tell them. I think it's been too long. 'Cause he got old. That's what happens to us. But hopefully I'm not there yet where I'm too old to do this. I still enjoy it.
What, do you mind me asking, how old were you when you first started practicing, if you don't mind?
I was 4 years old. No, I mean, no,
Well, that I can actually believe.
no, I'm kidding. You see the way he kept a straight face when he said that? He's a real lawyer. No, no I was 25.
Oh, wow.
No, 24 and a half. 24 and a
Okay.
half.
Okay.
24 and
Very
a
good.
half.
Wow. That's
Yeah,
amazing.
I'd graduated law school and took the bar in two states, passed in both states first time, and got admitted and started right away.
Well, there you go. Well, let's put you to the test here with something I know I don't know much of, and I'm sure some of our listeners or a lot of our listeners don't know of. But let's get right to it. What injuries qualify under New York law for pain and suffering? Now, in New York, not every injury automatically qualifies for pain and suffering and damages, and the law sets specific thresholds for what counts as serious injuries. But Mitch, when we talk about pain and suffering under New York law, what kind of injuries actually qualify?
Well, so it's a good question, but first we have to digress because it's important to know how the accident occurred because there are different laws for different types of incidents. So we're going to limit the conversation to personal injury. Okay, we're not talking about damage for property or damage to your business. We're talking strictly personal injury claims. Okay, now in 1972, when Nelson Rockefeller was governor, New York enacted a no fault law. And that no fault law had a monetary threshold for injuries. And that lasted until 1978. And in 1978, the monetary threshold was changed to the serious injury threshold under Section 5102 of the insurance law. And that threshold exists today, but it only exists for motor vehicle accidents, but motorcycle accidents are excluded. So, for motor vehicle accidents, that's car accidents, bus accidents, pedestrian accidents, truck collisions, any type of motor vehicle accidents that exclude motorcycles. But does include if you're a pedestrian and get hit by a motorcycle, because that's defined as a pedestrian accident, not a motorcycle accident. But for drivers and their passengers of motorcycles, they're excluded. Now, there's a serious injury threshold. And that serious injury threshold has various categories. And those categories include death, dismemberment, significant disfigurement, 90 out of 180 days immediately following the incident or occurrence where there's a complete disability, permanent consequential limitation, significant limitation, different categories. Judges struggle most with the permanent consequential significant limitation, those two categories. But I'm going to get to that in a second. For a trip and fall, for a ceiling collapse, for a fire, for a premises liability case, any other type of accident, a motorcycle accident, because that's excluded too. For all those other cases, you could have just a claim for your hair got messed up. There's no threshold. Now, of course, you're going to have a hard time finding a lawyer that's going to say, your hair got messed up, I'll get to work on this right away. Although, more realistically, a lot of times people call up and they say, I just got really scared. Now I can't sleep. Lawyers typically don't take that either. Typically, a lawyer that does personal injury work is going to look for some sort of physical injury, and then the subsequent mental anguish and nightmares or post-traumatic conditions that you might have, that can be part of the claim. Usually an attorney's going to look for a physical injury. But the law doesn't require any minimum injury. Instead, in motor vehicle accidents, car accidents, bus accidents, truck accidents, pedestrian knockdowns, those cases have a serious injury threshold. Now, that threshold's not by my opinion. That's the law. And people oftentimes, they'll call up a lawyer saying, I got into a terrible accident. Well, lawyer asks, what were your injuries? I wasn't really injured, but my car was totaled and it was really upsetting. What's my case worth? It's worth nothing because it doesn't meet the serious injury threshold. And the insurance carriers, they're not stupid. They make their money by collecting as much as possible in premiums and paying out as little as possible in claims. So if they think that your case doesn't meet the threshold, they're not going to pay. And they even go so far as, if they think your case might not meet the threshold, they might force your lawyer to file suit and at times even go up on appeal. Now, I lectured around the state for the New York State Academy of Trial Lawyers on the no-fault threshold for 5 years. 2 other attorneys just bring up new case in the law. And every year, year after year, I presented cases where victims had surgeries, shoulder surgeries, back surgeries, knee surgeries. And the insurance carriers were appealing them, saying, we don't have to pay, it doesn't meet the threshold. Because afterwards, they stopped treating. So they said, well, even if he treated, initially, he stopped treating them, there's no permanency. Now, sometimes the law said doctors would come in and they would say, based on the doctor's affidavit, an affidavit, by the way, is a sworn statement signed in front of a notary. That makes an affidavit. And a doctor's affidavit could come into evidence if they're the treating physician and they have the necessary prerequisites to be considered as evidence. The judge would say, of course, this guy meets threshold. The surgery, the doctor said it's permanent limitations afterwards. Other times, lawyers didn't do their job and the cases were thrown out. I say lawyers didn't do the jobs because sometimes it's written right into the opinion where the judge says he didn't put the proof in evidentiary form. So lawyers sometimes get sloppy. They can be overworked. They might not think the case is worth their time. They might just be careless people as it is. That's like any other profession. Sometimes people make mistakes. Only with lawyers, it's in writing. Fortunately, I haven't had that experience where an appellate division said I forgot to do something. And we do appeals in my office, and we've been successful. But anyway, so if somebody has a fracture, if it's a broken finger and there's a fracture, that immediately meets a threshold, even if they never go back to the doctor, as long as you could show the fractures from the incident. Significant scarring. Well, the standard for that is the injury one that is likely to make somebody feel embarrassed, shocked, and scorned in public. So typically, if you got a little scar that's underneath your bra, might not meet it. You got a facial scar, it's probably definitely going to meet it. Now, 90 out of 180 days complete disability. Okay, so that means you can't go to school, you can't go to work, you can't do anything but go to the doctor for at least 3 months. Then there's case law that says if you go back to work on the 91st day, then how could you have been completely disabled for 90 days? By the 90th day, you must have been only partially disabled if you could work on the 91st. So you won't meet that 90 out of 180 day category. But you also need medical proof during that time that you had injuries that kept you disabled. Then significant limitation, consequential limitation, that's the categories that all these other neck injuries, back injuries, shoulder injuries, knee injuries, did you have surgery? Did you not get the surgery? Is there a limitation of motion? And the courts have determined that there has to be both objective findings that are quantitative, meaning you can measure that objective finding. There's a limitation of motion in your neck. Well, how was that limitation of motion measured? Was it measured with appropriate medical equipment, or did the doctor just eyeball it? You need it measured with appropriate medical equipment. And then it's not that you measured it and the doctor said there's limitation. You have to compare it to typical ranges of motion. What's the standard? Otherwise, it's not enough. And the doctor has to put that in there. That's the quantitative limitations. You also need qualitative limitations. You have to say that, yeah, he can't do this, and it also affects him. So your shoulder's bothering you. Not only do you have weakness and a limitation of motion, but you can't do your laundry. You need help. You need to have a cart. You used to be able to carry it. You can't carry heavy grocery bags. Before you could. You can't play soccer. You used to play soccer. You can't play volleyball. You used to play. There needs to be not only quantitative, but qualitative limitations. Once you meet your threshold, then you're entitled to pain and suffering. If you don't meet the threshold, you can still get your medical bills paid. That's under your no-fault coverage. It's up to $50,000. Under the $50,000 in no-fault coverage, if you don't have a serious injury, you're still entitled to your medical bills paid. 80% of your lost earnings up to $2,000 a month. $25 a day in miscellaneous expenses, which could be transportation to go to the doctor. That could be a miscellaneous expense. But you need to submit your bills within 30 days to the no-fault carrier. And the no-fault carrier is typically the vehicle that you're in when it happened, not the vehicle at fault. So you could be hitting the rear. You're submitting the bills to your own carrier. But you want to get paid. because you got hurt. Well, if you go to the doctor for 3 weeks and then you're all better and you got the best lawyer in the world, you're not going to get paid. Because the lawyer's going to send your medical records to the carrier and they're going to say, is that it? And unless there's a fracture in there or significant scarring, you're not going to get paid. So people say, yeah, but the accident wasn't my fault. That's only part of the claim. First part is, how did it happen? Oh, it happened on a trip and fall? Well, then there's no threshold. Even if you only go to the doctor for 2 months and then you stop going, you might still have a case. If you can find a lawyer interested in representing you and there's insurance coverage and you can show that there was a notice of a defect that wasn't repaired, you might still have a claim. But with a motor vehicle accident, you're not going to get money for your pain and suffering unless you can show you meet a threshold, because the insurance carriers aren't going to pay no matter who your lawyer is. Now, a good lawyer, of course, will let their client know about the law, and additionally, and there's nothing unethical about knowing the law. A good lawyer can ethically tell their client, this is the law. This is what you need to prove. That's ethical. A good lawyer can tell their client the law before they even ask them how it happened or what the injuries are. An ethical lawyer could do that. But a good lawyer could also say, listen, if you're still having problems, if you present those ongoing problems to a doctor, that will be proof. That will be evidence in your case. Medical records can come into evidence. If you just go home when you're in excruciating pain and all you do is tell your dog, I can't play with you today because I'm in pain, there's no proof. And your case could be dismissed for a gap in treatment. There is good case law that says a gap in treatment may be enough to dismiss your case and you won't get a dime for pain and suffering. Even though you're in excruciating pain and you can't walk your dog, you didn't tell a doctor and there's no medical proof. And that's the law in New York.
I know, let's say, for example, you did have you're a model and you have a scarring on your face. Can cosmetic surgery also be implemented in? Does that count, or I'm not sure.
So typically, significant scarring, a scar is supposed to be permanent, right? So they'll look at you with a scarring case and they won't pay you right away. They'll want to wait 6 months to see what it looks like in 6 months.
Oh, wow. Okay.
And if it looks like it heals, you might not get paid.
Oh, wow. Okay. Wow. All right. Well, there you have it, folks. And thank you, Mitch, for answering my little side question over there. Thank you again. You heard it from the expert himself, Mr. Mitch Proner. And that'll do it for now. And thank you for taking your time to tune in, whether it's on our podcast or video broadcast. We really do appreciate you taking your time. And as always, remember, you can call us 24/7 at 1-800-321-1234, where consultations are free and confidential. Also, if you have not done it yet, please follow us on Instagram, TikTok, Facebook, and of course, YouTube. Like, share, and please subscribe so you get the latest updates. Now, before we go, Mitch, do you have anything else you want to add?
Most importantly, you should be well, you should be healthy. But if you are injured, you should get medical attention. And then at your earliest convenience, you should contact an attorney, because the insurance carriers, they've got lawyers and investigators working for them immediately. And they're not working to try and pay as much as they can on claims. They're working to see if they could get out of paying claims, even legitimate claims. They're investigating and they're hiring their lawyers to defend them. And you have the right. And most attorneys, like my office, we don't get paid unless we win. So to contact us, to consult, is always free and confidential. But most importantly, I wish you good health.
Thank you, Mitch. Thank you. Very wise words. Thank you again, Mitch, for yet another informative session with us. And thank you all for checking us out. I know I learned a lot. I hope you did too. We'll see you next time. Thank you, Mitch.
Thank you, Mel. All the best.